no matter how deluded and how far left they are, is tragic. But the response and the reactions that came afterwards were shocking. The VC of Hyderabad University was booked under the Scheduled Caste and Scheduled Tribe Act. So was the then Labour and Employment Minister, and a student organization president, ABVP Student Union's president, was also booked under the same act. The response that was gotten from the authorities was also very proactive. There was a committee set up with a judge to inquire into and submit a report on whether Rohit faced any sort of caste discrimination or whether his expulsion or suspension from college from the university was justified. The report was submitted soon and it was reported that the grounds on which the university took the decision was thoroughly justified. Only last year, in May, the police also submitted its inquiry report in which it was found that though all these major people, politicians, the Vice Chancellor himself were booked under the Scheduled Caste and Scheduled Tribe Act, Rohit's own caste certificate was acquired by forging documents, and that he did not belong to the scheduled caste, which was claimed. It was also submitted in the same report that he might be under a constant pressure, that since he is an active participant in all sorts of political activities on campus, somebody might inquire into his antecedents and it might get disclosed that he was not a scheduled caste as he claimed. These are the details of the past. Now, how does that happen that a bill is being brought now, around 9 years later, by the Karnataka Legislative Assembly? So the attempts were made the same year by Congress, All India, the Congress Committee's scheduled caste cell to bring such a legislation. But the call soon died down. And the result was that a legislation could not be passed, even though a draft was prepared in the same year. Now we have a bill which has been drafted, and officially the Karnataka government has taken a stand. The Congress has taken a stand that such a legislation is the need of the time to prevent caste-based discrimination. What does the bill contain which is so problematic? The name in itself, the title seems all right. In fact, it seems to be very morally appropriate. And anyone who would protest against it might be labeled a person who is a casteist and who supports any sort of caste-based discrimination. So I'll throw some light on the provisions that would be a part of this draft bill, that are part of this draft bill. I'll make it clear at this stage that a draft bill is not the final presentation that would be made in the Legislative Assembly. The provisions might be changed and there may be new additions to the same. So it might not necessarily get presented in the same form. But we can judge what would be the bill about based on the inspiring legislations which give it the foundation. So this bill has the purported objective of preventing any sort of caste-based and identity-based discrimination in educational institutions. It takes into its sweep all public universities, private universities, and deemed universities. Offences under the legislation are non-bailable and cognizable. which means that unlike many penal offenses, here the bail would be given to you only at the discretion of the court or the judge, and it would not be allowed to you as a matter of right. And cognizable here means that the police can make arrest without a warrant. Dangerous provisions, because we have to see the ground on where they are being applied. The universities. Here we have students aged from 16 till 28, 29 who are PhD scholars studying. And when we talk about Karnataka, the general category combined is a minority. It's only 5 to 6% of the entire population. So just imagine the sort of situation it creates for every general category student who enters an educational institution. Any first-time offender under the law would be liable for punishment up to 1 year of imprisonment and 10,000 rupees fine. Punishment for a repeated offense is 3 years and up to 1 lakh rupees fine. Any education institution where a complaint is made as to show that it has discriminated with any student in the form of denial of admission or extortion or in any other way, that educational institution is liable to lose support, government aid on the basis of that complaint. These are the provisions that we have in the draft bill. A compensation amounting rupees 1 lakh is to be awarded to the complainant. There are provisions to ensure that there is a special court which takes care of cases filed under the new law, a special public prosecutor appointed to these courts, and legal aid provided to the complainants. The law might seem harmless even at this stage. So I'll tell you what exactly is wrong with it. The present legislation is a dangerous concomitant combination of the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act 1989 and the Communal Violence Bill, which the Congress tried to enact time and again and could not do. This Rohit Vemula bill does not only extend protection to the scheduled caste categories, scheduled tribe, it also is applicable to the OBCs, other backward classes, Muslims and Christians, them being minorities. So only general category Hindus are excluded from protection. That is why the people that are being labeled oppressors and who are being attributed with guilty mind, mens rea. In law, when we enter a court of justice, the prosecution have the responsibilities of proving mens rea and actus reus. Mens rea is that a person had the intention to commit the crime. He had a guilty mind. And actus reus is that he has committed an act, an offense, which falls in the definition of a crime under law. But under this legislation, or under the legislations on which this law is based, guilty mind is presumed. It is presumed that you had a guilty mind. You knew that the person belonged to the scheduled caste, scheduled tribe, and now OBC and the Muslim or Christian communities. And secondly, that you did commit the crime. So both these things are attributed to you. You enter the court not to be vindicated, but to prove that though you have a criminal tendency and that your ancestors have committed several crimes, oppressive nature, discriminatory nature against these communities, you specifically come to the court to show that in this particular instance, you are innocent. As Pandit Satish Sharma ji mentioned, the concept of group guilt and what in law are known as principles of natural justice need to be discussed at this stage. The ground for this particular legislation has been laid in India since past few years. The last decade in India has been a decade of identity politics, of caste politics. With every year, instead of getting categories, castes out of the list of backwardness, we keep adding more people to the same. And this backwardness is not based on economic grounds or social grounds or educational grounds. It is solely based on a historical fiction that three Hindu castes have been oppressing a majority of 85% for the last several centuries. And therefore, it is necessary that not only affirmative action is given, but through law, their guilt is affirmed. So when we talk about these legislations, let us not forget the problematic aspect is not that we wish to stop any legislation from being brought about which prevents caste discrimination. No, our problem is that the group guilt is being attributed only to certain castes, and that the ultimate objective of this act is to affirm one, the theory of several thousands of years of oppression, which has never been evidenced, proven statistically before these legislations are brought about. In 2015, the central government amended the Scheduled Caste and Scheduled Tribe Act and added 47 new offenses to the list. And so on in 2018, it amended the act once again, taking away even the basic rights of preliminary inquiry before arrest and anticipatory bail. So in case, let's say a complaint is made against you under this law, and by you I mean any Hindu belonging to the general category, the police is bound by law to make an arrest immediately. It is not to look whether there are any suspicious grounds where arrest can be avoided, where it shows that the complaint is simply vexatious and is a product of vendetta or personal vengeance. In 2017, in Kashinath Mahajan's case, the Supreme Court tried to read down several provisions of the legislation which currently prevails in India, the Scheduled Caste and Scheduled Tribe Act, where it made several statements which are important as we discuss the Rohit Vemula bill. One, that in Indian jurisprudence, the Indian courts, the Supreme Court especially, has been time and again asserting that bail should be a rule and jail an exception. We have a case of Vishnu Tiwari ji, who spent 20 years in jail as an under trial prisoner Just imagine when such a person comes out of jail, has the world around him not changed? And when he finally got judged to be innocent, he had already spent a large part of his productive years in jail. He never got bail even to attend the funeral of his own mother, which is often allowed even in the case of people who are under trials in cases of terrorism, rape, murder. Here, there was no relief. Such is the situation of Indian jails and Indian criminal justice system. So the courts have been asserting the importance of bail. That please, the person who has been uh, labeled and accused is not yet a convict. Please do not keep him in jail. Get a bond signed. Fill the formalities. Get the formalities done, and please release them on bail when the necessary conditions of bail are satisfied. But in the case of Scheduled Tribes and Scheduled Caste and Scheduled Tribe Act, the offense is non-bailable and most prisoners, most under trials, keep rotting in jails. Second aspect that the court spoke on was the denial of anticipatory bail. So anticipatory bail is when any reasonable person apprehends that, let's say, I am employing a person belonging to the scheduled caste or scheduled tribe in my office. And so it can happen with any person belonging to any category. This person is not performing his duties as are required by his position. And I serve him, let's say, a notice of his removal from the position. And he threatens me with the act. What would any reasonable person do? He would approach the authorities and he would get an anticipatory bail that in case this person who has been threatening me with uh, filing a complaint under a non-bailable law, please, in case he approaches, I want an anticipatory bail so that I am not arrested and I'm not brought to the prison in handcuffs. In Indian society, the court said that once the stamp of a criminal is put on a person's head, he lives in shame. The society does not wait for him to be judged innocent. His life is ruined. Therefore, where the facts are showing that it might be a spurious allegation, please grant anticipatory bail. And it was also noted by the court that a large number, 95% of cases under this act are false cases. So, denial of bail or anticipatory bail is only defeating the rights of the accused. And he has a right to be treated at par with any other accused under any other penal law and provided some basic human rights. Third important observation that was being made by the Indian courts and is still observed by many courts in judgments is the presumption of guilt. Presumption of guilt means that the natural justice principle, which requires the prosecution to prove that I have committed a crime, is overturned. Instead, a person can go to the police authorities, claim that so and so person abused me and committed a crime under this particular legislation against me. Please file a complaint. And when a trial is conducted, we do not start from that person who is alleging my guilt proving that I have actually committed a crime. It begins by me or you approaching the court and stating that I am not. In jurisprudence, all around the world, it is a basic principle of justice. This is called natural justice, which means no law needs to specify it, explicitly mention it, elucidate it. These principles are so natural, so necessary to the very deed of justice, very act of justice, the very definition of justice, that they have to be upheld in every case, be it the administrative courts, administrative inquiries, disciplinary inquiries that are conducted in the Department of Government, or be it the courts, the general courts, the trial courts. Here, I approach the court when I'm labeled a criminal. I have to go and prove that I'm not. It is a principle of jurisprudence only that it is easier to prove that an act was done than proving that it was not done. So let's say if somebody says I used a casteist slur for them, it is easier for them to show by way of evidence that I did actually use those slurs or I did commit an act than for me to go and show that I did not. Usually the criminal justice system would act like this in any case, and especially in cases where the punishment is heavy because the life of an innocent is at stake. Any strong criminal justice system, a good criminal justice system, is defined by the fact that no innocent should be jailed. In fact, there's a saying that let hundreds of criminals, be free, but let not one innocent life be wasted. But it is not the case here because you're not assumed innocent. When we use this idiom, when we use this saying that has been the basis of every jurisprudence, every criminal justice system, every developed criminal justice system across the world, there's a presumption that the person who is coming to court as an accused is still innocent. He has to be proven guilty. So, A, you are presumed to be guilty. The burden of proving your innocence lies on you. The burden of proving your guilt does not lie on the prosecution. Once you show prima facie through evidence that no, I have not committed this act, then only the burden shifts on the other party. That itself is not enough. That you've shown that I'm not guilty. Now the burden shifts on the other party, and in case it fails to prove your guilt, that is when you are set free. That is when you're acquitted. You are declared innocent. You are judged innocent. These three things. Finally, when we are talking about this law, there's another presumption. And I've discussed it in the case of Scheduled Caste and Scheduled Tribe Act. It is the presumption that you know the caste of the person who is making a complaint against you. Now, in general circumstances, it might still be helpful for a person who finds himself in a road accident where the other person belongs to a scheduled caste or scheduled tribe. But what about a university? We have universities publishing the list of students who gain admission. And in that list, we have by category the names of students. Later, people get concessions in fee, tuition fee. We have the list displayed. Can, in that case, a general category student plead innocence and say that, no, I was not aware that this person belonged to the scheduled caste or scheduled tribe? How would he be able to prove it or she would be able to prove it? The other party will have so much of evidence, a leverage that, see, how is it possible? They know that we take admission based on reservation. They know that we have gotten concession in tuition fee. Our categories is displaced on college notice boards. So definitely this person knew. So there are two presumptions, not only the presumption of guilt, the presumption that you are aware of the particular caste of the person who is making a complaint against you. Finally, Satishji mentioned the concept of group guilt. We are a nation which has faced subjugation by the Islamic rulers for around 800 years. No, though that they were not able to totally colonize it, but a major part of our nation, our civilization was colonized by them. Then we had the British rule us for 200 years. On the eve of independence, we had many indigenous people who had converted to Christianity living in India, and so did many Muslims choose to stay back on the eve of partition and stay back in India. Many of these Muslims today and many of these Christians today may also have their ancestors and claim their lineage from rulers, and they do so, who subjugated the Hindu masses. Do we have legislations which criminalize the present Muslim youth or the Christian youth on the basis that once in the epoch of Indian history, Muslim rulers committed the worst sorts of excesses, aggressions against the Hindu masses? Do we have one such legislations? No. Instead, the Constituent Assembly of India chose to give the right of proselytization to the Christians. Hinduism is not a religion where conversion is a core. It is not. We had a minority ministry. We had the concept of minority rights. But just look at the state of the Hindus. Hindus who were subjugated for around 1,000 years are now being divided into two classes: the oppressed and the oppressors. One must ask, in history of 1,000 years, when did Hindus have the opportunity to oppress each other? We had trade relationships with every other civilization that existed in history. Every other civilization. We had foreign travelers, authors visit this country, write books on the wonders that they saw. Was it only when the Christian fathers and sisters arrived in this nation that they felt the need to civilize us? Was it without having a civilization that we built the wonders of the world that now are being recognized as UNESCO World Heritage Sites? Was it that a civilization that was busy fighting within itself, able to survive, able to uphold its identity for 1,000 years? It's not possible. And let's say 1%, let me make this assumption that once upon a time, a Brahmin family did not have good relations with a Shudra family. I prefer using the term Shudra and not the scheduled caste and scheduled tribe because today when this identity politics game is being played, let me just remind everyone, every year a new caste which might yesterday have been an oppressor is turned into an oppressed just by getting mentioned in a list. So I am using the term Shudra. So that particular ancestor committed a caste-based atrocity. Who is getting punished today? 5,000, 3,000 years later. A Brahmin woman who is caught by several scheduled caste, scheduled tribe students and is threatened using this following sentence. Either give birth to our children or we will book you and get you jailed under the Scheduled Caste and Scheduled Tribe Act. Will there come a time when these crimes that are happening against the general category people be vindicated by having a Brahmin, Kshatriya, Vaishya Prevention of Atrocities Act? No, it won't. At this point, it becomes necessary because I'm sure many of our listeners might still think that every year we get a news report, a news article claiming that the number of crimes against Dalits, an identity that is entirely manufactured and does not exist on ground. Let me just read from the NCRB data, and then after a brief remark, I'll conclude my part and hand over the mic to Satishji. I'm reading from the 2021 data. Total number of crimes that are committed in India in the year 2021 are 60,96,310. Out of these crimes, 50,900 crimes, which is approximately 0.83%, were committed against the scheduled caste. Crimes against scheduled tribes were even lower, 8,802. When we look at the percentage, it is 0.14%. Total, it is not even 1% of the total crime that is committed in this nation. 0.98% of the total crimes are committed against scheduled castes and scheduled tribes. While the crimes that are committed against the non-scheduled caste, scheduled tribe population is 99%, which means at this point in India, a general category student might be getting beaten up somewhere. A general category woman might be being raped somewhere. A general category person may be getting murdered somewhere. Because 99% crimes are getting committed against the general category. Crime rate. The national crime rate is 445.9. Out of which the crime rate against the scheduled caste is 25.3 and against scheduled tribes is 8.4, which means the crime rate in SC population is 18 times lower than average national crime rate. So how is it that the crimes against scheduled caste and scheduled tribes are increasing every year? And when I take this number, 0.98%, when I use this, let me just make it very clear. This 0.98% of total crimes does not mean all these crimes are caste-based crimes or caste-based atrocities. They include murder, they include theft, they include kidnapping, or crimes that are happening with every person, irrespective of caste, category, religion. Do we have a legislation? No. If 99% crimes are getting committed against general category, then it could also imply that the general category is the one that needs the strictest of laws to protect itself, right? So I'm going to just read this data. I could have gone on with other facts, but this is the same case with the 2022 data and 2023 data. less than 1% of total crimes. But who is presumed to be guilty? The general category. Who is being punished for the crimes that their ancestors never committed? And I'm going to repeat, never committed. Never committed. Who is still being punished for the crimes that they're not committing? The general category. Because the news articles that you see do not even tell of this 0.98% crime that is being committed against the scheduled castes and scheduled tribes in totality. How many of these 0.98% crimes are being committed by people belonging to the scheduled caste and scheduled tribe? The data is not published. So when we look at these laws and we let them be brought about and passed without any sort of protest, let us not presume, let us not have lived under the delusion that we are going to be saved. Because you might think that, okay, I am a person who is never going to commit caste-based atrocity. Well, 95% people who get jailed under this act never committed a caste-based atrocity. And in the 5% cases, a survey that was conducted by us showed that in this 5% cases, the caste of judge determined whether you were a criminal or were not. So in case the judge belonged to the specific categories, your conviction was more probable. Let us not let the legislators affirm anymore that our ancestors were criminals. Let us give some due credit to the warriors, the fathers of the civilization, and let us do some justice to the general category, which today is being labeled a criminal tribe at large, as Satishji mentioned. So you are born a criminal. It is a matter of chance when you are brought to the court. You are all criminals here. One day somebody needs to wake up and drag you to the court. That is all. So with this, I conclude this talk. I hope I was able to throw some light on the provisions which are available to us as of now and the dangerous implications that this act has for our society. Thank you. Over to you, Satish.
You are on mute. You are on mute. Satishji, you have to unmute yourself.
Satishji, you are not audible. You are muted. Host Katrina, can you send him a message that he is still muted?
In the meanwhile, I just want to take this opportunity to take some comments from the audience and present them to the speakers. So first of all, this is Dr. Om Sharma from USA. Jai Sri Radha Madhav to everyone. And I want to really thank Pandit Satish Sharma ji and Deepika ji for giving really very nice overview of the bill as well as the legislation or the draft bill going on and what are the dangerous points in this bill and as well as giving the background and really emphasizing this, which I also would like to emphasize, that one thing is there is no proven record of what is being politically manifested or fabricated, basically, that there was a kind of, there were atrocities and there were discrimination based on caste. That is not a proven fact. One thing is historically, you can look at several thousand years of history and it cannot be proved. And most of the accusations against a group means so-called the upper class. This is not upper class, upper caste they say, and which is not this never existed in the Sanatan Dharma. And if you take the atrocities, again, taking to the point, Indian Constitution in 1947, when India got independent after in 1950, they made this legal, that should be a discrimination based on caste. Who made that caste system? Maybe this was mainly manufactured by British, but it is in the Indian Constitution even today. So discrimination, when you talk about discrimination, then there is not only a certain number, 85% of the population or that caste, but should include 100%, which is so-called upper caste or lower caste, whatever they invented those terms. So in a way, all this appears to be bringing these laws or these bills or make these thing to law is really a politically motivated vendetta against a class which is has been the foundation of the country, and country is everything, whether it's economic foundation or dharmic in the sense, without those rules of dharma, the country would not have thrived for thousands and thousands of years. So I think that is the message I'm taking. And I'm going to take a question from Sri Krishna Sawantji, who has asked that Dr. Subhas Kasinath Mahajan versus the state of Maharashtra 2018. Isn't this the violation of Supreme Court judgment of the new Rohit Vemula bill? This is probably to Deepika ji.
The Kashinath Mahajan judgment, as is mentioned by you, was already undone by legislative means by the central government. So I have referred to this judgment in my talk, and I have also discussed the specific reliefs that it provided. It, to a large extent, and I'm not going to say totally watered down the act. No, it did not. Did it take away from the presumption of guilt? No, it did not. But it provided some reliefs that are available to any accused under any other criminal law. Why Rohit Vemula bill won't be a violation of this judgment is because in 2018 itself, the BJP ruled central government brought amendments making it very specific that any judgment of the court would not be making any impact on the provisions of the law. And it so happened that in another case, the next year, when the Supreme Court had to speak on this matter, it was made clear by another bench of Supreme Court that it was them who had made a mistake in the Kashinath Mahajan case, and it would basically be against the spirit of constitution if this legislation is read down in any manner. So the battle is only going to get multiplied. We're not going to get a relief. When the court itself, because the legislature has done indirectly what it could not do directly, cowers to it, takes a step back and states that no, it is us who made a mistake. How can we expect any relief? Because as I said, the SCST Act stands intact. This law only takes in its sweep the OBCs and the minorities, which are in any case protected under the Constitution. We have special rights for minorities, right? They are not unconstitutional or violative of equality. So, Kashinath Mahajan judgment would not be of relief here.
Thank you, Deepika ji. Since we don't have much time, I will ask just the last question, and the question is regarding the next steps. In light of this, whatever is being drafted and going through, how this based on like legal language and looking like uh, holding someone criminal without proving the act or without proving the action, like all these dangerous points, how that could be prevented and what would be the mode of or it has to be like at the mass level, at a large level, opposition of these kind of bills, which should not be passed. If they pass, then they are going to be definitely create a larger rift among society, and that is going to have serious consequences on everything of the country or national level. Any thought, Pandit Satish ji, Deepika ji?
Gee, firstly, thank you, Deepika ji, for spelling out what could be a legal minefield so clearly. Really appreciated. But just to make sure that this is brought into a very real world context, we often run the risk becoming hypothetical and cerebral and talking about things as though they're detached. If hypothetically I was delivering a talk in a Bharatiya university on an aspect of our history which a person found politically inconvenient for them, shall we say, they had a vested interest in the status quo and they found what I was presenting as of a challenge to their political position, and they decided that they qualified to take offense. Does this bill allow that person to make an appeal to the police authorities and have me arrested without evidence, non-bailable and cognizable, even though I'm not a citizen of Bharat? This is occurring within Bharat.
Yes, because the penal laws in India have extraterritorial operations. By virtue of the Indian Penal Code, which is now Bharatiya Nyaya Sanhita, we have territorial jurisdiction. So let's say an offense which is an act which is an offense within Indian laws is committed by you, even though uh, you are not an Indian citizen, you would be liable under the Indian law. Now, in case you have escaped and you are in the British territory, then there would be other procedure to then, get you back to Bharat and be prosecuted. But you're not free from, and if you're in Bharat, then the prosecution starts right away.
Okay, so just to make sure that this is crystal clear, if I'm an investor and I've invested in Karnataka in some sort of a business venture, and I have partners who are beneficiaries under this proposed bill, and they then decide it's of a financial advantage to them to enact a process on the basis of this proposed bill, the same applies. I could be arrested and and held incarcerated for an undetermined period of time, and in that time anything could happen. Is that correct also? A simple yes or no will do.
Correct.
Okay.
Yes.
And so this bill lays a path to destroying the investments that any person who is general category, either within Bharat or without Bharat, why would they want to do this? that's a question I think that we need to leave for another day. But in conclusion, and before I withdraw, thank you to everybody. I've got one thought, and that is a call to action. If anybody in the group has realized the parameters that are now being applied, the direction of travel, the intent of the persons who have presented this bill, and they want to do something about it, I think it's imperative for your interests, for the interests of your children, and indeed your connection to our homeland, it's imperative that you step forward, get in touch with Navneet or Dr. Om Sharma or any of the organizations who are hosting it, and step forward and say, yes, I want to get involved. And then you'd be welcomed, and let's move on to the next step, which will be to find out how best we can contribute to preventing what is such a gross injustice from being enshrined into Bharatiya law, and which undoubtedly will create conflict and harm the progress of our ancestral homeland and the birthplace of our civilization. So thank you, Deepikaji, and thank you for hosting this for Navneet, Dr. Omji, and Dr. Joshi.
Thank you. I think we are ready for our concluding remarks. We have gone little over time, but as Pandit Satish Sharma just mentioned, the journey is just beginning. It is not even started. We need to have more webinars of this nature. And I have gone even beyond that. I sit in Canada, where the land of free, they say, everybody equal in front of law. Men are born equal. That is the Constitution of United States of America, and they have a Second Amendment. So there's a lot to do, but people need to come out of their comfort zone. And we will listen to concluding remarks. We have gone over time, but we will do these webinars and create a movement, as Pandit Satish Sharma said. Most of the time, we just do something and it just dies down. It is for, we are doing this not for us, for our future generations and for the humanity. That I don't want to go over, there's so much I can say, but let's hear Dr. Professor Ajat Kumar Kaushik, who is also a scientist and great visionary, and totally committed to the cause. But we need all kinds of support from our people in terms of resources, in terms of their skill sets. Everybody brings something on the table. We all need to work like a cohesive team, and we will do it. As we say in Rig Veda, Sangachadvam samvadadvam samvo manamsi janatam deva bhagan yatha purve sanjanana upasate. It's such a wonderful Sangathan Sukta of Rig Veda. It's the last Dashama Mandal का अंतिम सूक्त है ये. We need to इसको चरितार्थ करने का समय है. Over to you, Ajad ji, for your concluding remarks. Sorry, all the audience, we got little longer. And Deepika ji, you will get better and better. You are amazing. Thank you. Thank you that you are here. Thank you. Ajad ji, please go ahead. Thank you. And then we'll conclude.
Thank you, Navneet ji. I really applaud the presentation by Deepika Sharma ji with a kind of primer from Pandit Satish Sharma ji. This is quite an eye-opener for us. But the sense I get is that this is tip of the iceberg. Now, when I hear words like draconian provisions in the law, I hear about that you're guilty prior to the process, which is against judicial ethics as such. When I hear that that so-called general category, I don't even understand what that means. I mean, it's a sort of excluded section of the society, which is a minority in itself. And the focus is on scheduled caste, scheduled tribe, OBC, Muslims, and Christians. And you see that, as Pandit Satish Sharma ji said, that we live in a globalized world for free trade or trade with tariffs, if I have to go a la Trump. Well, these kind of laws, they're going to hinder businesses and trade across the world. So the issue here is that there's a section of Hindu community that is being categorized as criminal by birth. It's a crime to take birth as a general category person. This is a very disturbing observation. Now, I hear the words like oppressors. Oppressors. Who were the oppressors? And I know that Deepika ji very clearly pointed out the last 1,000 years of history, and it is so obvious who the oppressors were. Now, when we see all these kind of things, where youth is getting targeted, universities are being affected, this is a very well-designed, I would even go on to the extent of saying evil designs to destroy a civilization. What I fail to understand is that if so-called general category are oppressors, then how could India be such a great civilization where Vedas were recited and written, where Upanishads were written, where we had Mahabharata, where we had Ramayana? They were all based on Dharma Yudh. So Dharma Yudh was the concept as a part of civilization that we always stood for Dharma. Now, I clearly see this because even the word caste, as I understand, I grew up in India, I knew the jati shabd was used for manushya. And there was no caste. Actually, it was a varna system based on the innate characteristics of an individual that they could contribute to the society based on their talent or innate skills or knowledge or capabilities. So, and that holds true even today. I mean, all over the world. I mean, not just India, actually. So the problem that I see here is clearly is India. We have a society that has lost its intellectual order. It runs by whims of some who are in power. And that's the danger for India. But now the question arises, as Pandit Satish Sharma ji said, and Pandit Om Sharma ji pointed out, and I know from India, K.C. Pandey ji is here. It should be an eye-opener for him as well as it is to us, that how we can allow such a thing to happen that would have an impact all across the world. India is not alone today. We live in a globalized fraternity. Diaspora is all over the world. General categories actually general categories more out of India today because of the situations in India. And India has lost such a huge talent. So the question that I see is that one of the things that I recognize is a systemic failure of education in India, where we have imposed foreign concepts and ideas like castes that comes from a Portuguese word castas, which is non-Indian, non-Hindi, non-Sanskrit. So how can that such a thing happen in India, something which is alien to India as such? So essentially, the Indian system or Indian society has to think about it. They really need to get back to their civilization. I mean, oppressors could not create the Vedic civilization that India had if there were oppressors. Oppressors didn't exist at that time, so they can't exist today either. So first of all, the educational aspect has to be emphasized with a kind of international university in India for Vedic philosophy and civilization, where all these kind of things that are being made out and a kind of narrative being created with falsehoods and false perceptions and so on, that is hurting Indian society and people across the world. The second thing that I see is that the denial of principle of natural justice. I mean, justice has to be equal for all. There can't be a separate justice for some and not for others. So essentially, it's a test of judiciary here for judicial ethics somehow, that how you can actually engage in denying justice to some and giving favors to some in the name of justice. Finally, I'd like to conclude, the problem lies with India. And if you look at United Nations, there are over 100 or 122 Christian secular countries that work by Christian values. There are about 50 to 60 Islamic countries that are not secular, but they work by Islamic values. There is a single Jewish country that functions by Jewish values, but billion people of Hindu origin are homeless because they don't have their own homeland. Nepal used to be one, and India is not. Now, why these kind of situations are happening is because Hindus are not able to govern themselves because Hindus don't have a homeland. There has to be a constitution that recognizes Hindu values, that recognizes Hindu Vedic civilization. Then alone we can think of Hindus having a home and governing themselves. And these kind of issues that are happening in India, they would not even arise. Thank you very much. I'm very grateful to you all for such a wonderful discussion. I thank our Navneet Kaushal ji, Dr. Om Sharma ji, Dr. Sadhana Joshi ji, Pandit Sharma ji, Deepika ji, for such thought-provoking, enlightening observations. And I think all across the world, we can't sit silent on these kind of issues. We must restore intellectual order of India, and we must